So welcome everybody. I'm Mel Levine, and I'm delighted to welcome everybody on behalf of the Jews United for Democracy and Justice group, of which I'm a part, Judge, and community advocates who are the co-hosts of this series of events. I've got a number of thank yous that I want to do before we go into the program. I want to thank our co-sponsors, who include Temple Israel of Hollywood, Valley Beth Shalom Synagogue, ICAR, Leo Beck Temple, Jewish Center for Justice, and The Forward. I especially want to thank Janice Kaminer-Resnick, the chair of Judge, and David Lair, the founder and the CEO of Community Advocates. They are the two who have put the laboring oar into these events. They've worked tirelessly, and we see the results, this extraordinary series of superb speakers and this wonderful audience. Tonight, by the way, may turn out to be the largest audience we've had. I also want to thank the remainder of the Judge management team. In addition to Janice and David and I, that consists of Zev Yaroslavsky, Rabbi Ken Chasen, and Carolyn Kelly. I want to thank our donors. We're deeply grateful to you. And if anyone wishes to donate, send an email responding to one of our announcements, and you'll get a response and you'll be able to donate, and we'd be very appreciative. Next week, our speaker is Jonathan Greenblatt of the Anti-Defamation League, addressing anti-Semitism, bigotry, and hate, topics that are especially pertinent now in light of everything that's occurring throughout the country relating to bigotry and hate. We think this will be an extremely important and timely evening. The week after that, we'll have political professionals talking about the 2020 election. And among our future speakers, we have Bill Kristol, we have George Will, we have Tom Friedman, and we've just added Congresswoman Karen Bass, the chairwoman of the Congressional Black Caucus, and to speak to us on police reform. And we also have just added New York Times op-ed writer Nick Kristof. If you are enjoying these programs and feel that others would, tell your friends about them and have them sign up. Others would be very welcome. And on a housekeeping note, let me mention that although tonight is at 6 o'clock, we're going to return next week, and every week thereafter, at least according to the current schedule, will be at 5 o'clock. So we'll move into introductions. I'll begin by noting that by my lights for decades, I viewed the University of California, I think appropriately, as California's most valuable crown jewel. And tonight we have three distinguished representatives from three of UC's superb law schools, Berkeley, UCLA, and UC Irvine, to discuss the Constitution in crisis. The first of those speakers is Berkeley Dean Erwin Chemerinsky. Erwin, it's not an overstatement to say, is a legendary constitutional scholar and an incredibly prolific one. He has an extraordinary number of items of significance to his credit, but he has admonished me to keep my introduction short. So I will only mention his most recent 3 out of 11 books. In 2018, he wrote We the People, a progressive reading of the Constitution for the 21st century. And he wrote 2 in 2017. One is Closing the Courthouse Door, How Your Constitutional Rights Became Unenforceable, and another, Free Speech on Campus. And in 2017, National Jurist magazine again named Dean Chemerinsky as the most influential person in legal education in the United States of America. We're also thrilled to have UCLA Law Dean Jennifer Mnookin, who sports not only undergraduate and graduate degrees from Harvard and Yale Law, but also to top off her legal and beyond background, she has a PhD from MIT in history and social study of science and technology. She's a leading scholar on evidence, and she's the founder and co-director of a group called Pulse, the Program on Understanding Law, Science, and Evidence. And further along those lines, Dean Mnookin was a member of the National Academy of Sciences Committee on Science, Technology, and Law. Her expertise in these areas is especially relevant as I'm expecting our conversation tonight to reach some issues relating to the assault on science, facts, evidence, and even truth that we're now facing in America. On a personal note, Dean Mnookin makes me feel pretty old, as I went to law school with her father, a very distinguished scholar and author in his own right, and a wonderful guy. But our distinguished moderator makes me feel not quite that old, as we went to school together in Berkeley a few decades ago, and he still, as you will see, presents as very young and very vigorous. Henry Weinstein, after a marvelous career as a journalist for the LA Times, New York Times, Wall Street Journal, and San Francisco Examiner, among numerous other publications, now teaches lawyering skills at UC Irvine Law School, coincidentally where Erwin was also dean. So Henry, I turn it over to you to moderate what I know will be a terrific discussion.
Thank you, Mel. Good evening, and thank you all for joining us. The mere fact that we're having a conversation about whether the Constitution will survive is a sign that the country's not in great shape. Not to mention that we're discussing that question in the midst of a pandemic and a profound nationwide upheaval in race relations. I'd like to just start with a few questions that are relevant to tonight's conversation. First, what are the powers of government to protect people in the face of a massive public health crisis? Next, will courts make it easier or harder for individuals to vote during a pandemic? Next, will the Supreme Court agree with President Trump's lawyers that he is above the law? Others are wondering, can Trump call off the election in November if he thinks he's going to lose? And finally, what will happen to the Supreme Court if Trump is reelected? To slightly reframe the big issue before us, I don't think the question is exactly whether the Constitution will survive. At least on paper, the Constitution will survive. But what's up in the air is how the Constitution will be interpreted and who the interpreters will be. After all, the Constitution survived the War of 1812, the Civil War, McCarthyism, and Watergate, but we shouldn't take the Constitution for granted. The Constitution does not protect itself. The Constitution needs us to protect it. Even if the country's not yet formally facing a constitutional crisis, I venture to say it is experiencing constitutional rot, a term coined by Yale law professor Jack Balkin. And listen to how he describes what constitutional rot is. The historical process through which republics become less representative and less devoted to the public good. Instead, they seek to maintain themselves in power and please a relatively small set of powerful individuals and groups. There are many signs of constitutional rot around us, including the growing evidence that Attorney General William Barr thinks his role is to be Trump's personal attorney rather than the lawyer for all Americans. Just a few hours ago at a House of Representatives hearings, Donald Ayer, who was the Deputy Attorney General under George H.W. Bush, said that he considered Barr the greatest threat in his lifetime to the rule of law. What is more starkly evident than the issue of the constitutional crisis is that we are clearly in the midst of a truth crisis that can have a profound impact. Regrettably, a significant portion of the population doesn't seem to accept the elementary facts, regardless of evidence, including the fact that more than 120,000 Americans have died after being infected with coronavirus. A chunk of our fellow citizens apparently still think it's a hoax, not a real danger. Thousands of them attended 2 Trump rallies in indoor arenas in Tulsa and Phoenix during the last few days. There is a critical correlation between a truth crisis and a constitutional crisis. It's difficult for democracy to function as it should when Americans can't agree on the most basic facts, no less what those facts mean. is even more difficult when the President of the United States is operating in a fact-free universe and encourages his followers to do the same. For months, the President has asserted that the coronavirus would disappear like a miracle or just fade away, encouraging behavior that put people's lives at risk. Trump, as I suspect most of you know, has specialized in what one of his key aides refers to as alternative facts. As I hope everyone watching knows, an alternative fact is not a fact at all. And thus far, the president has generated more than 19,000 of them. Whether they are the product of magical thinking or intentional deception, so-called alternative facts are dangerous to the well-being of a constitutional democracy. In his trenchant book on tyranny, historian Timothy Snyder implores us to believe in the power of truth. He writes, "To abandon facts is to abandon freedom. If nothing is true, then no one can criticize power because there is no basis upon which to do so. If nothing is true, then all is spectacle. The biggest wallet pays for the most blinding lights." And now I would like to turn it over to our two eminent scholars, Erwin and Jennifer, each of whom will speak for several minutes. Then we'll have a conversation between us, and then you will all get to ask some questions. Erwin, take it away.
Thank you. That was a wonderful statement, Henry. Thank you so much for having me as part of the program. It's just great to be together with Henry and Jennifer. I'm going to speak to just a bit of what Henry raised, and that's to say that I believe we are now in the midst of a constitutional crisis. I resisted using that term for a long period of time, but I was wrong. I think a constitutional crisis exists when there are consistent, unremedied violations of the requirements and norms of the Constitution. And that's what's happening right now. Let me speak of three areas where I see this happening. The first are the unremedied constitutional violations. The Constitution is no more than parchment under glass unless it's enforced, unless we follow it. And if major parts of the Constitution are violated and ignored, that is a constitutional crisis. Let me give a couple of examples. One is what's referred to as the emoluments clauses of the Constitution. I realized that prior to January 2017, many people thought that an emolument was a skin cream. But there are two provisions of the Constitution that use that word. One says that no officer of the federal government can receive any emolument, meaning benefit or present, from a foreign government without congressional approval. The drafters of the Constitution were very afraid that the fledgling nation might be influenced by benefits from foreign governments. And there's a provision in Article 2 of the Constitution that says that the president can receive no emoluments for serving in office other than the salary that's paid. That's because there was concern that a president might engage in self-dealing and benefit financially from being in office. Donald Trump has been violating the emoluments clause since the day he took office. He has personally profited enormously from being president. Lawsuits were filed, including one where I was co-counsel on January 23rd. They remain pending in the court, even though now we're in June of 2020. But let me give you another example of consistent violation of the Constitution. That concerns the spending power. Any constitutional scholar would tell you that the spending power is quintessentially in Congress. It is what Alexander Hamilton referred to as the power of the purse. President Trump wanted Congress to appropriate funds to build a border wall. Congress refused. President Trump created a stalemate that shut down the government for the longest period of time in American history. President Trump gave in, and then on his own, he decided to spend money to build the border wall, even without congressional authorization. This makes a mockery of the spending power and of the Constitution. But there's a second way in which I think we're in a constitutional crisis, and that's the put himself above the law. Take the investigation with regard to Russia and the obstruction of justice with regard to it. It's often forgotten that Robert Mueller's investigation showed that there were clearly criminal violations. Now, Mueller said he wouldn't offer any conclusions because of a Justice Department rule that a sitting president could not be indicted. But no one can read that report without thinking that criminal violations went unremedied. Or think of the testimony today concerning Roger Stone, with federal prosecutors saying that they were pressured by the Attorney General with regard to the sentencing. Or Michael Flynn, he pled guilty to crimes he clearly committed, but for partisan reasons, the Justice Department decided to withdraw all charges. And today, the DC Circuit, in a 2-1 decision that clearly is inconsistent with the law, said that was permissible. Or take the Ukraine. The General Accounting Office said that President Trump violated the law by refusing to have money spent that Congress had appropriated for aid to the Ukraine. It violates a federal law called the Impoundment Control Act. Or take what happened just a few weeks ago, where President Trump and Attorney General Barr, in clear violation of the First Amendment, cleared out lawful protesters for a photo op. Isn't all of that the president putting himself above the law? But the third area that I would talk about is undermining checks and balances. I worry as to this president in the future, what the checks and balances at the core of the Constitution mean. We've seen that the Justice Department has taken the position that a sitting president can't be indicted. We've seen that impeachment is a toothless remedy so long as the Senate is the same political party as the president. We've seen the president say he doesn't have to comply with congressional subpoenas. How then do we check the president? So to me, I answered the question by saying, I'm an optimist. I think the Constitution will survive. But I also want to be a realist. No form of government lasts forever. No democracy has lasted forever, and ours is in danger. Now, one thing that I feared would happen that hasn't, and I think it's a transition of much we're going to talk about, is I worried at the start of the pandemic that it would lead to the government taking on even more autocratic powers. We've seen in many countries around the world, Hungary, Thailand, the Philippines, the government's doing exactly that. But because President Trump denies the existence of the pandemic and its seriousness, he has not used it as the occasion for taking on these autocratic powers. The government clearly, to answer Henry's question, has the ability to stop the spread of a communicable disease, but its actions have to have a real and substantial relationship to public health to be allowed. I think overall what our state and local governments have done is constitutional and justified. I wish the federal government had provided them more support.
Thank you, Erwin, and thank you, Henry, and thank you for the invitation to join this evening. I fear that I'm here slightly under false pretenses and that I am not a con law scholar, and Erwin is obviously an incredibly distinguished one. My background, as you heard in the introduction, is more in the realm of evidence, and so it might not surprise you to hear that I think, as Henry already suggested, that the constitutional crisis that we're facing today is also deeply linked to an evidence crisis, to a crisis about challenges over whether we have shared ways of getting to understanding methodologies or ideas about truths that we can believe in. I don't think we have to have some simple, straightforward truth in which we all agree, but I think that when there's too much divergence in terms of both how we think about getting to truth and what counts as truth, it makes the rule of law and our constitutional regime harder to have be secure. And I think that truth has been under just tremendous assault. We saw this even before Trump was elected, but we also saw it in the opening days. And I think it's worth taking just a minute. Henry spoke of the phrasing alternative facts. It's worth just remembering where that first came about. It was right after the inauguration, when there were these, when Trump and Sean Spicer claimed that these had been the biggest crowds ever to watch Trump and his inauguration. And yet photographs showed otherwise. And it became pretty clear that there was substantial data and evidence that showed that claim wasn't true. And Kellyanne Conway said, no, these are just alternative facts. And of course, that got mocked, but it also became something that became a classic part of the way of doing business under this presidency. We can already see in that moment some of the sort of key marks of untruths, even when they're not important, braggadocio, and the willingness to just keep saying something in the hopes that that will convince at least a substantial part of those who are listening. And I think rather too often that's been what has occurred. Henry mentioned this, but I think it's again worth repeating. According to the Washington Post, there have been 19,127 false or misleading claims made by this president in 1,226 days. That's kind of mind-boggling. Now, I don't mean to be naive or say that other presidents were perpetually truth tellers, but I think that the blatant willingness to say and repeat loudly that which is convenient rather than that which is accurate creates enormous challenges. And that's run up against all of the constitutional dynamics that Erwin has ably described. And then comes the pandemic, right? Then comes a moment when it's very hard to do that. You know, we've heard many of the things that Trump has said about the pandemic, that the coronavirus would weaken when we get into April and the warmer weather, that it's a hoax, that it's not as bad as the flu, or it's like the flu in a reasonably bad year. Of course, then later he said, I've always known this is real. This is a pandemic. I felt it was a pandemic long before it was called a pandemic, he said. I've always viewed it as very serious. He's told us it will go away without a vaccine. And we're not going to see it again, hopefully after a period of time. And of course, we see that he doesn't wear a mask, that he holds rallies like the ones that he just held, and he doesn't behave in a way that takes it seriously. He pulls us out of the World Health Organization in the middle of this crisis. And so how does this come back to the constitutional questions and these questions about the rule of law? What's the link? Why are these things connected beyond simply, you know, a word like crisis? I think it has to do with whether we can have some kinds of shared understanding across political difference, across divides, about how we think about what counts as knowledge, or what the rule of law needs to look like. That we have to have some degree of shared foundations, shared ways of talking and thinking about these things in order to have the rule of law operate effectively. And my worry is that we've reached something of a breaking point in that regard. I'd be curious to ask Erwin, as our con law expert, to talk a little bit about the space between constitutional norms and constitutional law, about rules versus law, because we see the flouting of both, and I think they interact and support each other in deeply concerning ways. And I think that partly leads to not just the rule flouting and law breaking that Erwin's described, but it also leads us to things like the politicization of mask wearing and the flouting of efforts at safety in the name of what, in my view, is a deeply distorted view about liberty. It's true that we have, limited but clear case law saying that that the kinds of moves that states have been attempting to make to keep the virus at bay are quite likely constitutional. There are some limits to that, and perhaps we'll talk about those. But the challenging question in this moment is, it seems to me, how we begin to reclaim any shared space for thinking about pathways to talk across, pathways to reduce polarization rather than increase it, at a moment when not only do we have a constitutional crisis, but we have, thousands of people dying every day, and where America may be about to be on the list of countries that, Europe won't allow our citizens back in, precisely because of how poorly we've handled this. Now, do I think there's a full-fledged constitutional crisis or a crisis to the rule of law? I guess my own answer is that I think we are very much at risk of that for all the reasons that Erwin has described and more. But I don't know. I'm a UCLA person. I'm a Bruin optimist. I guess I do see some reasons for hope. And I think it's worth mentioning just a couple, including the surprise outcomes from the court over the past week or so. we've entered a world where there are many people who very cynically believe that law is being reduced to politics, potentially on both sides. Certainly it's what many of us see in Trump and those who support him. But this past week, we had two outcomes from the court that I think surprised many court watchers and are worth making mention of. One, of course, is Bostock, which was the case about employment discrimination and LGBT and trans individuals. And that case found 6-3 that employment discrimination against trans and LGBT people violates Title VII of the Civil Rights Act. And it was an opinion written by Justice Gorsuch. And I don't know that many would have predicted that outcome. And then we also, of course, had the 5-4 opinion in the Department of Homeland Security versus the Regents of the University of California, in which Roberts refused to let the president rescind DACA on the basis that had been provided, finding that that basis was so thin that it was arbitrary and capricious and didn't provide adequate justification or explanation, especially vis-a-vis the policy of forbearance to childhood arrivals. Now, to be sure, that opinion, the Bostock opinions in many ways are pretty robust articulation that the language of Title VII of the Civil Rights Act, even if those who wrote it might not have recognized that they were using language that protected against discrimination against LGBT people, that it in fact did. It's a pretty solid conclusion in that regard, at least as I read the opinion. This other opinion about DACA is much more fragile. It's really a ruling that that depends on the particularities of the administrative record, and where a more robust administrative record would lead at least one justice to shift back. But still, I think it's worth noting and appreciating that, that in this moment, we've had these opinions come out of a court in unexpected ways that perhaps illustrate some minor degree of the creation of balance. And I'll give one final example of that, and then we'll open it up, which is something that happened just today, which was 65 professors at George Washington University, 65 law professors wrote a letter strongly rebuking Attorney General Barr for his failures to fulfill his oath of duty and his failure to support the Constitution. And they talked about several of the things that Erwin brought to our attention. One was the Mueller investigation, his overstated claims and his very misleading summary. A second was about the sentencing of Roger Stone. And a third was about the clearing of Lafayette Square and his role in that during the peaceful protests. But what's striking to me isn't just the fact of it, but it was a really bipartisan group. It was a set of law professors coming together and saying as loudly as they could that they wanted to support rule of law values, protect the Constitution, and to call out the Attorney General for his failure to do that. And in a way that captures so much of what we're facing right now, because it reveals that it's a bit of a crisis, right? When you have a bipartisan group of distinguished law professors coming out against the Attorney General who attended that law school, that shows you that something's wrong. But it also shows you some of the energy and force around trying to articulate the core constitutional values that we hope can be brought back. And so I guess the final question I'd love to pose to both Erwin and Henry is, what's the path back? How do we recreate not just a stronger culture of rule of law, but a stronger culture of shared ideas about how to get to truth and shared norms about the methods by which we get there?
Before we get to the path back, I'd like to just pick up on something that Jennifer just said and then pose a question to Erwin. I think perhaps even more significant than the law professors at George Washington is that more than 1,900 former federal prosecutors, both Democrats and Republicans, have said that Barr should resign. I mean, I used to write about federal courts. I did it for many years, and it was a very stark thing. There were lots of people on that letter who never agreed with each other, probably on anything prior to that. So I think that was pretty stunning. And although I share some of Jennifer's optimism about the two decisions last week, I want to turn back to Erwin for a second to ask him about something about a court, one of the decisions the Supreme Court did make this year that I think is very relevant to the November election, an election that may be very difficult to conclude in a timely fashion because of all of the absentee ballots that are likely to be cast. And Erwin, I would like you, if you would just talk a bit about what happened in Wisconsin and what you think it portends.
Sure. Wisconsin decided to go forward with its presidential primary and other primary elections on Tuesday, April the 7th. Because of the pandemic, many people decided that they wanted to vote by mail. In order for the ballots to be counted, they would need to have been in by April 7th. A federal judge said, in light of the huge backlog of ballots in the post office that haven't been delivered, he was going to order that ballots would have to be in by the following Monday, April 13th, in order to be able to be counted, extending the time just so the ballots could be delivered and turned in. The United States Court of Appeals for the Seventh Circuit affirmed, and then it went to the Supreme Court, and the Supreme Court 5-4 reversed. The case is called Republican National Committee versus Democratic National Committee. There was no author of the majority opinion. It was an opinion of the court, what's called a procurement opinion. And they said, we look with disfavor on changing the rules for elections soon before they're being held. Here, the judge changed the rules before it was being held. This violates the principle that we've articulated. Therefore, the ballots have to be in by April 7th in order to be counted. Justice Ginsburg wrote a vehement dissent saying, we're in the midst of a pandemic. What the majority was doing here was ignoring health realities and putting people's lives at risk. And we saw that happen. We saw huge lines of people, say in Milwaukee. There's reason to believe some who became infected by standing in those lines when it could have been accomplished just by allowing this extension for when ballots would have to be turned in. One of the things that was troubling to me about it is that it was a case brought by the Republican National Committee, and the 5 justices appointed by Republican presidents sided with that. The defendants were the Democratic National Committee. The 4 justices appointed by Democratic presidents sided with that position. To me, it was so reminiscent of Bush versus Gore from December 12th, 2000. I worry what it means for the November election. We're seeing a huge upsurge in COVID-19 right now throughout the country. No reason to believe that it's going to be better come November. We need to find a way to facilitate people voting in November without putting their health at risk. And if the Supreme Court is going to say that federal courts can't do this, the alternative that we saw in Wisconsin, people having to choose between not voting and putting their health at risk.
Well, that's a very scary proposition, and I'd like to turn back to Jennifer. One of the things that's also been happening recently is that the president and the attorney general have been talking a great deal about the possibility of fraud if there's a lot of mail-in ballots. Is there any evidence of that?
That's a pretty simple answer. No, I mean, it's been debunked quite substantially. It's just not a claim about which there's any evidence to support, and yet it keeps being repeated. In fact, Trump's pivoted back to that again in the days after his rally, and it's another example of kind of the deflect and distract through false claims that just get repeated over and over again. I mean, obviously, there can be issues with election results, period, but there's no evidence that mail-in ballots would create meaningful or significant fraud issues. There's also no evidence that there'd be foreign interference or greater foreign interference than we're already having via social media and other mechanisms if we went to mail-in ballots. So it's simply not fact-based.
So Erwin, do you think that there's any way, a lot of people are wondering, could Trump postpone or call off the election in view of there being some state of emergency in the country?
The answer is no, President Trump can't do that. Let me elaborate a bit. The time for the election is set by federal statute. At the beginning of American history, there wasn't a set day for the election, and each state decided its own day for the presidential election, and it went on over about a 6-month period. In 1845, Congress decided that it would be the first Tuesday after the first Monday in November. It'll be November 3rd of this year. Congress, by statute, could change the law that exists in that regard. The day in which the Electoral College meets is set by Congress. Congress could change that. But keep in mind, the Constitution says that the president's term ends at noon on January 20th. So if a new president and vice president hasn't been chosen by then the Speaker of the House of Representatives would become the president. I think that would mean there's a strong incentive for Republicans as well as Democrats to want to make sure that there is an election held this fall. Now, there are other scenarios that the Constitution allows that are frightening. There is no requirement in the Constitution that the people in a state determine who the state's electors will be. In theory, a state legislature can choose the electors for that state. And imagine a state where the state legislature is controlled by Republicans, but they think that the vote might come out for Democrats. In theory, the state legislature will just choose the electors because of the pandemic. I don't foresee that happening, but constitutionally, it would be permissible. There is also the scenario that everyone raises of what if President Trump loses, but refuses to accept the outcome of the election. He says it's all a result of fraud and he's really the winner. And what if he refuses to leave office? Then we will have a constitutional crisis by any definition, a constitutional crisis unlike we've ever seen. And then it really will turn on the courts and it may turn on the military and what happens then. But then we really are like what we've seen in so many parts of the world where the Constitution becomes meaningless and we're no longer a democracy. I think we all could agree, whatever our politics, that hopefully we'll never come to that point in time.
Well, I would certainly agree with that, and I hope it doesn't come to that. I have to say that the reactions of the General Mattis and a couple of the other leading military figures after what happened in Lafayette Square was heartening in that regard. I'd like to turn to pose a question to both of you, starting with Erwin. It's something one of the people in the audience asked, and it's something that's been on my mind. If Biden wins the elections, are either of you in favor of post-presidential prosecution of Trump for his alleged crimes? Is this important for the sake of justice, or is it a dangerous precedent?
Yes, I think that there should be an investigation of those in the current administration for their crimes, and that includes the President of the United States. Going back, I think President Obama made a big mistake in not investigating and prosecuting for torture those in the Bush administration who were responsible for it. I think that, again, this goes to the principle that no one, not even the president, is above the law. It's interesting that the Trump administration has taken the position, as has the Justice Department, that a sitting president can't be indicted and prosecuted. That then has to mean that the indictment and prosecution has to occur after office if a person has violated the law. So I would favor some kind of truth and reconciliation process, but it would also have to include indicting and prosecuting any who found to violate the law. And that goes all the way up to the President and the Attorney General of the United States.
All I would add to that is, again, I'd bring it back to the question of evidence and investigation. I think it would be deeply problematic to say that there couldn't be further investigation of that which occurred during this presidency. And, there's a lot that we know and there's a lot that we think we know, but I also suspect that investigation would clarify more that we don't currently know. I do worry. I mean, I think back to the chants about lock her up, right, during Trump, when Trump was running. And I do think that there are dangers in going after those who have left power. And that too is something we see more frequently in states with which we'd rather not be associated. But it cannot be that anybody is completely above the law, certainly not even the president.
Thank you, Jennifer. Something that people have been asking about in terms of the way our system works is whether or not checks and balances are out of whack with efforts to enforce provisions of the Constitution because legal remedies take too long. Defendants can slow things down in cases like this. Do you think there's a need for any changes, Erwin?
I do, and that's what I was saying in my opening remarks. I am very worried about checks and balances. The question is, how do we check the president? If we now see that impeachment removal isn't a realistic check, and if a sitting president can't be indicted, if the sitting president doesn't have to comply with subpoenas, if in fact high-level executive officials don't have to comply with subpoenas, where is the check on the president? If the president can go ahead and spend billions of dollars without congressional authorization, where is the check on the president? And I hope that there will be a return to a much more robust system of checks and balances. To put this in historical perspective, I think that it's now been for several decades, with the Democratic and Republican presidents, we've seen a growth in presidential power without checks. And I'm very worried about that.
Yes, the Congress has been pretty much supine, and it's gotten to a point where, Trump said during the campaign that he could shoot somebody on Fifth Avenue and not lose a supporter. Well, one of his lawyers said that he could shoot someone on Fifth Avenue and not be prosecuted, which I thought was truly, truly astonishing.
Erwin, I want to throw a question at you, which is where you would, if you were going to give an origin story for this constitutional crisis, where would you locate it? How far back would you go? What would you choose as a defining moment or two? I mean, I think there's many to choose from, some of which are prior to the beginning of this presidency for sure. And I'm curious where you would draw that line.
I would separate two questions there. When did the imperial presidency begin? And when did it become a constitutional crisis? I think the imperial presidency really began post-World War II. I mean, Arthur Schlesinger wrote his book, The Imperial Presidency, around 1973. But I do think in recent years, as Congress has been more paralyzed by partisan divide, the president has done ever more by executive order. And I'm troubled by that. I criticized it when President Obama was doing some things that way, and I criticized it with regard to President Trump. But I think the constitutional crisis really began with the Trump administration. That I think the systematic, unremedied constitutional violations, the undermining of constitutional norms is something that we've seen with regard to this presidency, unlike any before in American history.
I'd just like to add a brief comment to that as someone who lived through Watergate and wrote articles about some of the Watergate slush funds. President Nixon and his aides often attempted to sidestep or subvert the Constitution. As far as I can tell, President Trump does not even acknowledge the Constitution. That's a fundamental difference.
Right.
Well, let me give you an example of that. President Nixon allowed his aides to testify before Congress as part of the impeachment hearings and proceedings. However, President Trump refused to allow any of his aides or any who were surrounding him to testify. The former acknowledged the constitutional process. The latter denies even the existence of the constitutional process.
Yeah, no, I think that's a very important distinction. And it also comes back a little bit to the way that Trump flouts norms as well as rules, right? There's all kinds of things that we might have thought of as almost rule-like that get revealed as simply norms when he refuses to participate in them.
So one member of the audience has a pungent question for two law school deans. And here's the question. Did left-wing academic arguments questioning basic precepts contribute to the challenges to truth today from the right?
It's an interesting question, right? I mean, there was an academic movement to complexify ideas about truth and what truth looks like, and to suggest that truth has more relativistic components than might have originally, than many might have assumed or understood. And the question is, does that in some ways, does that line of thought in some ways contribute to a world where there's simply alternative facts, where we talk about alternative facts and where there's no shared way of agreeing upon things? I think it's an important question, and I think that I do think that as an intellectual tradition, there is some engagement there, some spaces of connection. But I also think that the efforts to complexify truth-telling were much more about situated knowledge. We're saying that one person's truth isn't necessarily another person's, and that but that didn't necessarily mean that anything goes. There's a French scholar named Bruno Latour, who was one of the core thinkers about this in science studies, in the area of science and law. But as Bruno Latour once said, even he stops for speed bumps, right? Even he slows down when he goes over speed bumps. And I think the point, and I don't want to distract us from the core, the point is that it's really important to recognize that how we see and understand the world and what looks powerful and persuasive to us may deeply be affected by our identity, by our situation, by our education, and that those differences should be recognized and acknowledged and celebrated. But that doesn't mean that you can simply say anything and call it truth. There has to be some boundary.
Erwin?
Can I just say I agree? I think Jennifer said that wonderfully. The left and the right are equally responsible for the partisan divide in the country. And the left and the right will look at the same thing and often see it differently. But I would simply add where Jennifer ended. There are still facts. The pandemic is there. Coronavirus is being spread. That's a fact. Masks help to stop the spread of coronavirus. That's a fact. To deny it puts people's lives in jeopardy. Climate change is a fact. And so it seems to me that we should be able to, whether we're liberal or conservative, agree to those kinds of facts, even though, of course, Jennifer is right, how we see the world is ultimately influenced by what we start with and who we are.
Right. And some scholars who started some of those movements that you were referring to, Jennifer, were also talking about the fact that there was legal teaching, at least at the time I went to law school, which is sort of in the early Middle Ages, that just simply ignored the existence of certain people or the way that the law operated on them. Talked about neutral principles when things simply were not neutral. So
that's exactly right.
Yeah.
That's what makes it complicated.
Right. So let's move on to the next question, which is, a member of the audience, Joseph, asks, can Congress use the power of the purse to enforce compliance with its demands?
Yes. Congress can put strings on grants. So Congress is able to say when it gives money to state and local governments, you have to meet these conditions. Like if you want federal law enforcement money, you got to prohibit chokeholds. So long as the conditions are clearly stated, so long as they relate to the purpose of the program, and so long as they're not unduly coercive. Likewise, when it comes to the executive branch of government, Congress can say, executive, we're going to only fund these things if you do the following. That's what the power of the purse is about. But to me, that's what's so troubling. When Congress says, we're not going to give you money for the border wall, and Trump says, that's okay, I'll spend it anyway. And the courts so far haven't stopped that.
Next question. What do you both think about the state of abortion rights and whether they're endangered?
I think they're very much in danger. Despite the opinions that Jennifer referred to for last week, we have to look at the composition of the current court. John Roberts has been on the Supreme Court since October 2005. He has never voted to strike down any restriction on abortion. Samuel Alito and Clarence Thomas are on record saying that they believe that Roe versus Wade was wrongly decided. Neil Gorsuch and Brett Kavanaugh have not yet participated on the Supreme Court in an abortion case, but we know from their writings before going on the court that they're very much likely to be foes of abortion rights. Gorsuch from a book that he wrote, Kavanaugh from an opinion he wrote on the DC Circuit. So I think there are 5 justices right now who will either effectively or explicitly overrule Roe versus Wade. They might effectively do it just by upholding the laws that have been adopted in so many states, imposing restrictions on abortion that make them so much less available. Or the court might at some point explicitly overrule Roe. I should mention here, there's a case pending right now before the Supreme Court, June Medical Center versus G. It involves a Louisiana law that said that in order for a doctor to perform an abortion, the doctor had admitting privileges at a hospital within 30 miles. 4 years ago, in Whole Women's Health versus Hellerstedt, the Supreme Court declared unconstitutional an identical Texas law. but that had Justice Kennedy joining with Ginsburg, Brierson, and Kagan. And the question will be, what will the Supreme Court do now without Justice Kennedy as the fifth vote? Will they follow a 4-year-old precedent? Will they come up with some way of distinguishing it? Will they overrule it? Or might they even indicate a desire to reconsider Roe versus Wade? We'll find out soon, maybe as soon as tomorrow morning.
I would agree with everything Erwin just said. I would just add that in some ways, I'm even more worried about what he termed the effective overruling rather than the very explicit overruling. Both are deeply problematic from where I sit, but I think that the absolutely explicit overruling creates space for a politics and movement around this that might have more power than just continuing to cut away at these rights and chip away at them bit by bit without ever actually saying the words that it's overturned. So both are very serious risks, and one could debate which is more concerning.
Right, but they can certainly erode abortion rights without outright
That's right.
overruling Roe versus Wade without question. I want to go back to the coronavirus situation for a moment, which you touched on briefly earlier, Erwin. Saying that there was some court authority, obviously precedents to deal with it. Could you talk a little more about the legal basis for restrictions on citizens or related to the coronavirus or mandating that certain forms of citizen conduct?
Sure. State and local governments have what is called the police power. It's their authority to do what's not prohibited by the Constitution. It's their authority to protect public health and safety. In fact, in 1799, Congress passed a statute saying that quarantining was left to state and local governments. It wasn't a power of the federal government. There's very little authority from the Supreme Court about the power of government to stop the spread of communicable disease. But in Jacobson versus Massachusetts in 1905, the Supreme Court said that the government can take the actions necessary to stop the spread of communicable disease so long as those actions have, and I'm quoting, a real and substantial relationship to public health. And what most courts have held in the last few months is things like shelter-in-place orders, business shutdown orders are constitutional because of a real and substantial relationship to public health. And in fact, there's been one Supreme Court case that involved a situation of whether or not a church based on free exercise of religion could violate assembly regulations. And the district court said, assembling people, even for religion, leads to the spread of communicable disease, that the religion doesn't have an exemption from that law. And the Federal Court of Appeals agreed, and the United States Supreme Court agreed, rejecting the religious freedom issue and saying that stopping the spread of communicable disease justifies limiting assemblies, even assemblies for religious purposes.
I would just add a couple of additional thoughts. I mean, one is that Jacobson doesn't make the bar, it gives states a fair amount of leeway, right? They can't do things that are arbitrary or completely unreasonable or can't be defended as connected to what's reasonably required for public safety, but they have a fair amount of leeway to act in these situations. One of the things I've been worrying about and thinking about recently is the pandemic and the connections to privacy, right? Some of the countries that have been handling the coronavirus much more successfully than we have also been relying much more on technological mechanisms for tracking and tracing, for using apps, for requiring information, and for being much more proactive, but also privacy invading in the effort to track and trace. And I guess I think there's certainly an argument under Jacobson that there's a place for invasion of privacy in order to help public health and public safety. But I do worry if we go down paths like that and we begin to use technologies for tracking and tracing, how can we make sure that they are as privacy protecting as they reasonably can be? And what happens once this particular crisis is over if we become more accustomed to gaining and using that kind of information and having the government or company or corporations or for that matter, universities have access to that kind of data. So these are real concerns.
Erwin, you want to weigh in on that too?
I agree with Jennifer about that. I think that one of the hard issues that's going to come up is when universities say, if you want to come on campus, you have to consent to having this app on your phone. Or an employer says, if you want to come to work, you have to have this kind of app on your phone. And is that meaningful consent? And the underlying issue that Jennifer rightly points to is, how do we balance privacy interests with the need to stop a pandemic that's killing so many people? And I think those are enormously difficult questions for which there's no clear answer in precedent or even in consensus right now in society.
Okay. One final question, and then I'm going to let you both make some closing statements. What if a member of the Supreme Court, particularly an elderly member of the Supreme Court, were regrettably to die? Several people have asked this question in the next couple of months. What do you think will happen?
I think it's clear. President Trump will nominate somebody and the Senate will quickly approve that person. Mitch McConnell has made clear that what occurred in 2016 with Chief Judge Merrick Garland would not be followed now. Jennifer rightly drew a distinction between rules and norms. One of the norms through American history is that the Senate considers and votes up or down on a president's nominee for the Supreme Court. Prior to 2016, 24 times in American history, there had been a vacancy on the Supreme Court in the last year of a president's term. In 21 of 24 instances, the Senate confirmed, and 3 it didn't. Never before until Chief Judge Merrick Garland had the Senate said, no hearing, no votes. That's a violation of a norm, not a constitutional rule. But they're not going to follow the new norm from 2016. So I think until and unless the Senate changes hands in September, President Trump will nominate and the Senate will confirm. If the Senate changes hands to Democrats, then obviously it wouldn't be done. But if it doesn't, then until January 20th, so long as there's a Republican Senate, President Trump will get who he wants through and he'll have the votes to do it.
I'd like to ask each of you to perhaps take 90 seconds to 2 minutes to make a couple of closing remarks, starting with Jennifer.
Thanks. First of all, thanks for this opportunity to have this conversation, Erwin and Henry. It's always a pleasure to get to talk to you about topics like these and otherwise. I guess I want to come back to what Erwin just said about if there were a possibility of a change on the court, because I agree with his analysis. But what I also think is that points out that the failure to get any kind of vote on Merrick Garland was in fact one of the places we could locate an origin story for some of the crises that we're in now. It's obviously just one among many. It's certainly not the exclusive or only one. But I do think that was a moment that not only changes the makeup of the court, but changes how a set of people feel about the rules and whether they're operating in a reasonable and fair way, and whether law kind of just becomes politics all the way down. And it's that culture and that fear that law really isn't more than politics that I think is part of what's so distressing and polarizing now. It's why I pointed to the 2 cases that are at least a glimmer of a sense that there might still be some additional ways of thinking about things, but that's obviously very fragile and limited and very concerning. And so for me as a dean of a law school, where obviously I believe deeply in the importance of the rule of law as not simply eroding into pure politics all the way down. That's what I worry about. And it's also why I worry greatly about the question about the pathway back. We didn't really get to that. We didn't really get to how to change the collective way we think about all of this, or are able to come together in a somewhat less polarized way, hopefully in the year to come. But I sure hope we can get there. Thank you.
Erwin?
I would begin where Jennifer ended. I think that the hardest question is, how do we heal the deep partisan divide that exists in the country? I think that we had that opportunity this spring. A crisis does provide the chance to bring a country together. We saw after 9/11, the country came together. It could have come together to fight the pandemic. Unfortunately, we have a president who, instead of using this to heal the country, used it to further divide the country. I worry that this sounds partisan, and I don't mean it to be partisan. I would hope that both liberals and conservatives could together say that what President Trump has done with regard to the pandemic, minimizing it, telling people not to wear masks, is tremendously destructive. That liberals and conservatives should be able to come together behind the rule of law. Liberals and conservatives should be able to come together behind facts and science. Now, despite all of what we've said, I am by nature an optimist. I think that we will get past the pandemic. We will get past this threat to the rule of law. And I do think the Constitution will survive. I look at the course of American history, and there's been such tremendous advances over the course of American history in equality and freedom. There's a huge way to go with regard to racial equality, as we're talking about now. But that can't deny how much progress there's been. There's a huge way to go with regard to sex equality. But look where we've gone. Or think with regard to gay and lesbian rights. Just 5 years ago, the Supreme Court said that gays and lesbians had the right to marry. Just a week ago, the Supreme Court said that federal law prohibits employment discrimination on the basis of sexual orientation. There's been tremendous advances of freedom, and I think they'll continue. I think Martin Luther King Jr. was right when he said that the arc of the moral universe is long and it bends towards justice. But what I try to tell my students is that's not going to happen by itself. It's going to take all of them and all of our effort to make that happen. So the message I try to convey to them is that we need to fight harder and better than ever before in order to advance freedom and equality, in order to uphold the rule of law.
Thank you both. Thank you both. And I'd also just make a couple of closing comments. First, I'd also like to thank one of the other organizations that helped put this on, Stephen Weiss Temple. I also want to remind the audience that there will be a program next week with Jonathan Greenblatt from the Anti-Defamation League at 5 o'clock, the normal time. And that, one moment, I think my video went off. Okay, sorry. And that there will be future events in coming weeks with a lot of very interesting speakers. KPCC's Larry Mantle will be interviewing George Will. Pat Morrison, the LA Times, interviewing Bill Kristol. Warren Alney be interviewing New York Times columnist Tom Friedman. And then there will also be the New York Times' Nick Kristof and Congresswoman Karen Bass. So, and I want to thank everyone for joining us tonight. And I want you to tell everybody, all your friends about America at the Crossroads, and wish them good health. And don't forget to vote. Good night.